Okay, good morning.
Morning.
Morning, Judge. How are you?
Good. Hey, we'll go ahead and get started on the oral argument in State Farm versus Knap. I assume you both can see the clock in the corner of your screen there.
Yes.
Does the appellant wish a little help in keeping track of the time for rebuttal? How much time do you want for rebuttal?
5 minutes, please, Your Honor.
Okay. This has been broadcast on YouTube. So with that, and I think you know the other members of the panel, Judge Lambert and Judge Harris. So we'll go ahead and get started. The appellant may proceed.
Thank you. May it please the court. I'm Warren Quavnik on behalf of the defendant below State Farm. I've requested 5 minutes for rebuttal. I assume that's going to be marked on toward the end as opposed to coming off now. This is an appeal of a judgment in the plaintiff's favor following a trial for uninsured motorist benefits. We raised 2 points on appeal. With the court's permission, I'll address them in the issue that we've presented them in the sequence that we've put them in the brief. Our first point is that the trial court abused its discretion in denying a brief mid-trial recess to conduct a records custodian deposition to confirm whether a cervical MRI was in fact the plaintiff's, and then also denying the equivalent post-trial relief. Here's the backstory on this. About 25 days before trial, the defense counsel took the deposition of the plaintiff's surgeon and learned at that time that there had been MRIs of the plaintiff's low back following his 2018 surgery. It was arranged that defense counsel would obtain those post-surgery lumbar MRIs, and he obtained a disc on that day from the facility. He immediately forwarded the disc on to his radiologist, Dr. Foley, to interpret the MRI studies. There had been no indication ever during the litigation of this case, through discovery, through interrogatories, through depositions, or through a prior subpoena to the facility, NSI, that the plaintiff had ever had a pre-accident neck cervical MRI. No reason to think that any such films would be on the CD that he had just obtained. Dr. Foley reviewed those studies and provided a report to defense counsel during the first week of trial. A couple of days later on the weekend, defense counsel, this is the weekend between the 2 days of trial, defense counsel reviews the report and realizes for the first time that the CD that he had obtained actually contained a pre-accident MRI of the plaintiff's neck.
You weren't sure it was the plaintiff at that time?
We're still not 100% sure, although which is why we need to determine this. But you're right. Part of the issue why we're not certain that it's the plaintiff is that no discovery up to this point suggested the existence of a pre-accident MRI. Defense counsel alluded to other things about the films themselves that might suggest it wasn't the plaintiff's, but there's not been a lot of detail on that. Evidence that it was the plaintiff's is the very same day as a shoulder MRI that we did know about, but the shoulder is not at issue in this case. The neck and the low back are at issue in this case. This is an important piece of evidence. There were no other pre-accident lumbar or cervical MRIs. The defense theory in this case is that the conditions that the plaintiff is complaining of are not acute, they were not caused by this accident, and that they were pre-existing and degenerative. This 10-year pre-accident cervical MRI would be very compelling evidence to support that. The report we got from Dr. Foley, which is in the record, shows pre-existing conditions, including at the very same 3 levels that the plaintiff claims he needs a future neck surgery. So this would have been very powerful evidence.
Well, how do we know it would have been powerful evidence given the lack of a proffer? I mean, how do we know Dr. Foley wouldn't have said, well, comparing this in 2004 to 2014, it was just a de minimis change, which suggests that it wasn't progressive or very little progression. I understand it wasn't an evidentiary ruling, so you weren't required to make a proffer, but isn't a proffer relevant to some of the issues in considering whether to grant a continuance or whether to grant a new trial?
Well, let me address that in a few ways. When the issue first came up mid-trial, there was no issue at that point in time as to a proffer. It did become an issue when we were arguing it post-trial. But I would say that it wasn't necessary to say what Dr. Foley would have said to make this an important piece of evidence. Dr. Foley's opinion at this point is based on the post-accident films. This is not an acute injury, and this is pre-existing. The films could only have supported that. The films show the pre-existing problems.
Oh, would you agree it wouldn't have been particularly supportive if the film from 10 years earlier showed very little difference?
No, I think if it showed very little difference, I think that tends to support our position that if the conditions pre-accident and post-accident are very similar, that's helpful to the defense, Your Honor.
Well, it would show, I mean, your argument is progressive degeneration, right? So if there's almost no change for 10 years and then the film taken after the accidents were dramatically worse, wouldn't that cut against your argument?
If the films were worse, it might, but the point is that the 10-year-old films show degeneration already and desiccation and bulges at the issues that we're complaining about.
Right, but in determining whether to grant a continuance, don't you think it'd be helpful for the trial judge to know if this was a game changer or would merely be a slight support for the party asking for the continuance?
Well, in retrospect, I suppose it could have been helpful, but I think pre-accident MRI showing degeneration, the degree to which they're a game changer is a matter of degree. This is, at least to some extent, a game changer. The pre-accident films are something you don't always have. In terms of the materiality of this, there's a body of case law, as the court knows, where a plaintiff fails to disclose his pre-existing conditions. That can get a case thrown for fraud on the court. The courts recognize that pre-existing conditions go to the heart of the case. This is not a clean pre-accident MRI. This shows degeneration. The degree to which it might have changed is a matter of degree. This is an important piece of evidence, and I think the court improperly discounted it. There were no other pre-existing films, pre-accident films, and to say that the post-accident films is a valid substitute evidentiary-wise, I think completely overlooks the importance of pre-accident films. I understand what Your Honor is saying. Would it have been helpful to load up the evidence in terms of, or the proffer in terms of how devastating not having this was? Sure, but I think the film in and of itself is important. There was nothing else like it in the evidence. The other thing too is when the continuance was denied, it wasn't because of this. The continuance was denied for two reasons. One is if it's not the plaintiff, then we're wasting time for nothing. If it is the plaintiff, then any and all relief can be handled post-trial. So it wasn't denied mid-trial for lack of evidentiary importance. It was denied really for that kind of reason. And it would have been a short continuance just to go and figure this out. Oddly, I've not heard any denial since this issue came up that this is in fact the plaintiff's MRI. They're saying that we didn't exercise due diligence or things along those lines. But if this was the plaintiff's, they could hardly complain about the lack of diligence. It means there's some very serious ramifications if it turns out that this was the plaintiff's and it was not provided in discovery, either through the third-party subpoena or in discovery from the plaintiff himself.
What if there's little or no difference between the 2004 MRI and at the time of trial? I mean, you're talking about you had a motion for new trial, post verdict. All right, wouldn't it be important for the trial judge to say, okay, well, doctor, now that you've been able to compare both things, it's significant or insignificant, or shouldn't that be a factor in the judge's discretionary call whether to grant the motion for new trial?
Well, perhaps, but again, I think if the films pre-accident and post-accident are largely unchanged, that supports the defense position that this accident had minimal impact on the plaintiff. I think the way defense counsel was going about this, and I can't say it's inappropriate, is there's a threshold question here. Is this the plaintiff or is this not the plaintiff? Everything else becomes moot. I think, it would have been a very short matter, and it still would be a very short matter to put that particular issue to bed. If it is the plaintiff's, then it opens up a whole set of things that need to be determined. But to answer Your Honor's question directly, the degree to which the pre-accident and post-accident films have marked a progression doesn't take away the fact that this is a 10-year-old MRI that shows degeneration and problems at the very same levels that are at issue in this case.
Well, was a factor not but I mean, defense counsel had this MRI, 25 days before trial, and could have looked at it or could have gotten the report. And in fact, it sounds like you did get the report from the doctor, your CME, but just didn't look at it prior to trial starting. So, I mean, I get it that you're saying that the plaintiff didn't disclose everything, but that being said, you did have it well before trial. Not you, but your side had it well before trial and didn't take any action on it, and that could have ameliorated any of this discussion.
Well,
Right.
let me clarify that a little bit. He had the CD about 25 days before trial. I don't know that it's necessary for defense counsel to open it up and try to interpret films. As far as due diligence, nothing had suggested there would ever be any pre-accident films on it. It was sent off to the expert. He authored his report on April 14, which was pre-trial. Defense counsel only received the report during the trial, not prior to trial. He received it, I believe, the Wednesday or the Thursday, I think, before the Saturday when he looked at it. So we were already into trial when defense counsel received the doctor's report. He didn't receive it.
Defense's expert had received the report well before.
The expert had authored the report on April 14. It was
Right.
not forwarded to defense counsel until the first couple of days of May. So
Should that be held against the plaintiff?
well, it should be held against the plaintiff only if it's his MRI. If it's his MRI, he could hardly complain that we didn't do enough to figure out that it was being disclosed. In that scenario, yes, it should be held against the plaintiff. But if it's not, then you're right. Obviously,
The delay from April 14th to the time the continuance is requested should be held against the plaintiff.
if the claim is that we should have figured out that we'd been denied important discovery that pertained to the plaintiff and that he didn't disclose to us, yes, I don't think he can complain that we didn't do enough to figure out that information was being withheld, Your Honor. I think that that's something he could hardly complain about under the circumstances.
Well, but the plaintiff's expert, well, I mean, with the plaintiff's approval, that data had been supplied to you, what, the April 2nd or so?
April 4, but with everyone's understanding, including plaintiff's counsel's understanding, that it only contained the post-surgery lumbar MRI. Of course, that was provided. Plaintiff's counsel himself says he was unaware about the existence of this prior cervical MRI. Whether the plaintiff personally knew is a whole other issue. I would also point out that in the case law, due diligence is not an absolute. If there's an easily correctable injustice, then the court should. And this would have required either mid or post-trial, a very brief deposition to figure out what is or at least could be a very important issue. I'm running a little low on time, so if I could, I would like to move on to very quickly the golden rule issue, if the court is agreeable.
Let me ask you about as to the void dire, the argument in void dire, assuming that was a wrong state, that's improper what the plaintiff's counsel did. If there was no quote golden rule argument made during closing, do you think that the comment made during void dire in and of itself would justify a reversal?
I've argued in my brief that we should have gotten a mistrial for that. It's not a strong appellate argument to say that was an abuse of discretion to deny.
Well, it's not a per se reversal when you get a golden rule argument made.
It is not. It is not.
It's still harmless error discussion. So.
It is, understanding that the special standard makes it the appellee's burden to show no reasonable possibility. I want to address briefly the golden rule argument. The Bew case, and this is a point that one of the points that I really hope the court comes away with. The Bew case that the trial court relied upon involved a different argument. That's the case where the argument is set forth in footnote 2. It does use references to quote you, referring to the plaintiff, but there's two important differences between that case. One is our case, I think, is clear in context. We're talking about a hypothetical experiment that's only nominally directed to the plaintiff. The word you is described as the subject of the experiment at least 50 times during the closing. The other thing about Bew is nothing in the Bew argument was tied to the amount of money the plaintiff was asking for. And that's the critical aspect of a golden rule argument. What the court in Bew wrote was, other than the fact that you was referring to the plaintiff, the court in Bew wrote, the argument did not strike at the sensitive area of financial responsibility and hypothetically require the jury to consider how much it would wish to pay or receive if it were involved in a similar situation. So Bew just didn't involve a golden rule argument, whether or not you meant the lawyer or you meant the jury or you meant the plaintiff. In our case, by contrast, that's exactly what this was. This was a quote experiment specifically and explicitly designed to address how much money it would take for you to go through what Mr. Knapp has gone through. The fact that this was couched in terms of an experiment directed to Mr. Knapp, I don't think changes the fact that the jury was implicitly and explicitly being put in the shoes of Mr. Knapp, specifically to decide how much they would accept for this. The SDG case we've cited in our brief says that even when an attorney does not explicitly ask the jurors how much money they would wish to receive in the plaintiff's position, comments may violate the golden rule if they implicitly suggest that the jury place itself in the plaintiff's position. That's what this was, particularly with the empathy comment in voir dire setting the stage for this. The jury is told in
particular closing argument went on for several pages of the transcript. Should there have been interruptions and specific objections at some point during that, or should have just gone on uninterrupted?
Well, the plaintiffs, on appeal is saying that it was waived. I think that it was preserved for appeal. The objections bookended the argument. As this was beginning, defense counsel went sidebar and said he feels a golden rule argument coming on, and the judge told counsel to be careful, and he assured everyone, plaintiff's counsel did, that this was not going to be a golden rule argument. Then we had, yes, it was a lengthy argument. Ideally, would there have been more in the way of objections? Sure. But shortly after, I think within 2 pages, the parties went sidebar again. Defense counsel said he was renewing his motion. There really wasn't a motion, but he was renewing the issue. And I think it's important how the trial judge dealt with this. The trial judge didn't say it's waived. The trial judge accepted it on the merits, overruled the objection on the merits on the basis that she did not perceive this to be a golden rule argument, and then assured counsel that she understood the position and the record was clear. I think when the
You're
court
at 4 minutes now, if you want to just let you know as far as rebuttal time.
Thank you. I think if that answers Your Honor's question as to the objection, I'll save the rest of my time.
It does.
Thank you.
Thank you very much. May it please the court. My name is Chris Carlisle, along with Andrew Pickett, who tried the case. We represent the appellee, David Knapp. Going back to the first issue, and even before that, if the court has had the opportunity to review the hearing transcript from the motion for rehearing, you'll see that the court was remarkably actively involved and went through these issues and found no prejudice and found that a fair trial overall was presented. You also see the order on the motions for rehearing, which is extremely detailed and goes through all the elements for each of these arguments and goes through exactly why the trial court was denying the motion for rehearing. The context of the first issue is obviously important, and it was touched on a little bit by the panel previously. April 4th, they get this MRI. April 14th, the discovery deadline ends April 12th. Their expert doesn't prepare his report until April 14th, 2 weeks before trial. They don't meet with the expert. They don't get the report until the first week of trial. And then after the weekend, after 5 experts have been presented by the plaintiff, after an opening statement has been made, they suddenly say, we just discovered this. And I think it's a tremendous stretch to argue due diligence was exercised when they had this for 25 days and their expert wrote something about it 2 weeks before trial. I'm still suggesting it would have been inappropriate to do what they were asking for, even if they had brought it to the court's attention earlier. But you cannot suggest it's an abuse of discretion when a week of trial has gone on and they say, suddenly we figured out that there's some additional thing that we don't even know what it is.
Can you
Going to
put
the point about materiality.
Can you put them in the haystack and then complain on how long it took them to find it?
Your Honor, I don't think it's a suggestion that we put the needle in the haystack. This came as a result of some discovery or questions. There was a discussion about this on May 6th, and it's a little bit unclear, but apparently the expert said something about it and they went and got these films. There's no suggestion since then that there was any sort of abuse of discovery. They've never brought that up. The trial judge at the time said, I'm not going to continue this, but if you can come back later, if you have some evidence, perhaps that there either should have been disclosed and wasn't by the MRI company, by the doctor, by the plaintiff, there's been none of that. And that was what the court was suggesting there, not that I'm going to revisit it later on. But a very material point that we heard over and over during his argument right there, and we also see in the initial brief and the reply brief, was that this showed evidence of pre-existing conditions. That was never argued to the trial court. It was never argued to the trial court. What happened was at trial, he says it would probably change the result based on the anticipated testimony of Foley. At the hearing on the motion for new trial, he said, I did talk to Foley about that. And the court says, what did Foley say? He says he has an opinion, assuming it is Mr. Knapp. We just don't know whether it is. And I don't want to articulate his opinion improperly. Later on at the end of the hearing, we didn't know about this. So my point being, and again, I agree with Judge Evander that it wasn't necessarily sort of an evidentiary issue where a proffer was required, but it is required in the sense that they're asking for relief, meaning that the continuance should have been granted or post-trial discovery should have been granted. One of the elements when you're requesting a continuance during the case is to show that it would result in an injustice for the movement. Why on earth would they not have their expert who's at trial say, I'm going to proffer this. I did review it and it would change my opinions and it's remarkably significant. That is very important. And also, when they're looking for post-trial discovery, they had to show that it would probably change the result and that it was material. They never did that. And so I don't know how you can suggest that the trial court abused its discretion when all they say is, yeah, we had it for a month. Yes, our expert looked at it 2 weeks ago. Now we're in the middle of trial. We don't know what it says. We don't know if it's him. We don't know if it's material. I'm not going to tell you whether it is or not, but please give us a continuance. And that was an abuse of discretion for the trial court, which is exactly what happened here. And also it was interesting because the trial judge that took over on May 6th, that the judge who was there the previous week had a medical issue, and she was all confronted with this 10 minutes after sitting in the middle of a case. So I think when you go through the factors that are required here, and the court specifically found that there was a lack of diligence, which I think it's very difficult to argue that when you have something in your possession for a month, there's no suggestion of any impropriety. There's no suggestion at this point of any withholding of discovery or improperly doing that. The court said, if that's the case, bring it to me later on and we'll deal with it, but I'm not continuing it now. So I think the context of where we are is remarkably important.
Well, the lack of diligence certainly goes to the court's refusal to grant the continuance during the trial. But when the court then says, but let's address this post-trial, and then refuses to, saying it wouldn't be relevant because of all the other post-accident reports that we have. How is that not an abuse of discretion?
Well, for two reasons, Your Honor. The court, if you read the court's comments, I think, again, she's not saying, let's bring it up after post-trial. She talks about it in the context of sanctions. If you read the court's comments there, and they try to say, look, she said we could bring it up post-trial. So there's two issues. One was, she said, I'm not doing a continuance now. If for some reason this evidence, if we're in the middle of trial, if it was improperly withheld for some reason, let me know about it. We'll deal with it then. Secondly, they moved for a new trial and raised in their motion that it should have been granted. And so when you go through that, at that point, what are the factors that they're talking about in the Roberto case, which they cite, which also cites the court cited the Bray case, which had the same factors, that it could not have been discovered before trial by the exercise of due diligence. The court found that due diligence was not exercised. And I think when you're talking about the timeline that it just went through, you can't suggest that was an abuse of discretion to find that. There's also a factor that talks about it being discovered since the trial. Clearly it wasn't. The court specifically found that. And then I discussed already that it would probably change the result and its material. So when you're getting into a post-trial request for additional discovery, those are the factors, none of which were met. And I think there is an important distinction between what the trial court was suggesting concerning sanctions, perhaps bringing that to my attention post-trial, versus I'm not ruling on this now, bring it up again.
Well, wouldn't it be impossible to show that this new discovery would possibly affect the verdict if they don't even know it's Mr. Knapp? Shouldn't they at least be given a chance to establish whether it is the plaintiff's CT?
Your Honor, given the timing of this, I would suggest no, and it wasn't an abuse of discretion. But again, even if the court, it would have a much stronger argument if on May 6th, the first day of the second week of trial, when Dr. Foley is about to testify, if he put on anything in a proffer about the materiality of this. It maybe is Mr. Knapp, maybe it's not, but it's their burden at that point to say to the trial court, we need a continuance because if it is, here's how it affects our case. You can't do this. And all they're suggesting now is we should be able to take it now. And maybe if it's not him, it's no harm, no foul. But if it is him, we should get it. The court should have declared a mistrial. Now, how do you let 5 days of testimony with experts being flown in and testifying about, how do you let opening statement go when you knew about this or should have known about it a month before trial and say, yeah, we didn't look at it. I didn't meet with my expert. I was not aware of it until the middle of trial, and no prejudice would result to the plaintiff if you let us do this. There's tremendous prejudice there. They didn't proceed with diligence to look at these things. It would have been a different story if they did, and perhaps there'd be different issues before us. But we have the context of where we are. And given these facts, and given the fact they failed to demonstrate any materiality whatsoever, if it was Mr. Knapp, should be fatal to this cause. And you cannot find that the trial court abused its discretion by denying a continuance at that time.
Let me ask you about the sympathy, empathy
Yes, Your Honor.
distinction, if you would. What would you suggest is the reason why we don't allow a jury to consider sympathy in reaching a verdict?
Well, obviously, Your Honor, it should be based on the facts and it should be based on the evidence presented. And I understand the concept of golden rule arguments. There were really
okay. Well, then, given that, I generally agree with that. How does empathy play into a jury's determination of returning a verdict based on the facts as presented by both sides and the instructions of law as given by the court? What role, if any, does empathy have in that?
Well, the role it plays is that it's a distinct concept from sympathy. And so there were essentially three questions asked early on in this in the voir dire, where the questions were directed to, again, the jury instruction, which just reflects what you said. You cannot use sympathy in doing this. And the questions, you understand the distinction between sympathy and empathy. At that point, the trial judge, when there was an objection made, said, I've never really seen it in the context of voir dire like this. I get the argument, stay away from that. He did stay away from it. Three questions in voir dire, essentially. The trial court said specifically later on, I don't feel there was any taint to this jury. And to suggest that the jury in the entire trial was affected. And
there's two issues here, so I'm trying to narrow it down. One issue is whether it's a proper line of questioning during jury selection. The second is, if it's improper, was it harmful in this case? So I'm just asking about the first question. Is it proper?
Well, again, it's a little bit unique and there's nothing clear on this, but we have case law from the Florida Supreme Court, Lovato, that we cite, obviously stating that you can question jurors regarding the legal doctrines that are at issue. And so when you're trying to have you're going to have a jury instruction that the jury is going to be given later in the trial, where they're asked to and required to apply certain standards to the legal issues involved, making sure they understand what those words mean and what they're going to be asked to do is proper. The trial court found it to be proper. Secondly,
what if he states the law during that voir dire? I mean, didn't Mr. Pickett in this case say the law is you cannot use sympathy, but you can use empathy? That's not what the law is. Isn't that what he told during voir dire?
He asked them questions. Do you understand the distinction between those two? And then these jury instructions specifically says you cannot use sympathy. Can you follow
the law and not use sympathy, but use empathy? That's not the law.
If it's, well, where does the jury instruction say that you can't use empathy? And then I think the trial court found.
Empathy? I mean, empathy is the ability to share someone else's feelings or experiences by imagining what it'd be like to be in their shoes, basically. I mean, if Mr. Pickett had said, okay, you can't use sympathy, but you do have the right to put yourself in the plaintiff's position and share their feelings when you evaluate the evidence and reach a verdict, I think everybody would jump up and say, what are you talking about? Are you kidding? Rightfully so. And you're fighting a losing fight here and spending your time on something just as opposed to say, you ought not to talk about empathy in voir dire. As Chief Judge Evander is alluding to, it's harmless there. And I think even your opposing counsel says, if that's all that ever was said, we'd really have a hard time on this issue. Seemed to me that's the way you ought to take your route here. Then we'll go to the second part here and talk about your closing argument.
Well, Your Honor, I will just point out that the trial judge in his comments and also in the order found that there was a legitimate distinction there. And the jury instruction doesn't specifically do that, but I would agree with you. And I would agree with opposing counsel that
I agree. There is a distinction between empathy and sympathy, and you can't use sympathy as the jury instruction tells you. But you don't then say, well, but here's this other concept that it's okay because you're not going to get a jury instruction that says it's not okay. And we all understand the golden rule argument that says you can't do that, so you can't backdoor it, no matter how shrewdly one wants to put it in there as a trial counsel.
I understand, and I hear what you're saying. I would just point out the trial court disagreed. Obviously, you can disagree with the trial court, but again, in the context of the entire multi-week trial and 3 questions, and said, I don't want you to go there anymore. He didn't. And the trial court specifically found that even if it was improper, as you're suggesting, there was no taint and it wasn't sufficient enough to change the outcome of this case.
Well, if it gets you off the schneid here, I agree with you.
Thank you very much. Let's
I
move
think
on
that
to
one
the.
is harmless in and of itself, but then it lumps in, it morphs into the closing, which becomes more interesting. Yeah, so why don't
Yes.
you go into that?
Thank you. We argued below, and I think that the trial court didn't specifically find this, but there's a significant waiver issue that's present here. We have this brief discussion saying, I think he's about to go into a golden rule argument, and says, no, I'm not going to do that. I'll be careful. Then you have, as he mentioned, 50 references to you, but there's also, I think, maybe 13 references to Mr. Knapp. And a lot of the questions are asked in the sense, or the use of it, he was giving an example. Mr. Knapp, you have had to go to the doctor. Mr. Knapp, you were told you have herniated discs, etc. 50 times, again, they say you was mentioned, and as I think Judge Harris pointed out, 50 times if that was so offensive, there were no objections made. We cited the case, and again, he says there's a couple pages later in the transcript, but there was also a break of 14 minutes, and they came back in, he talked about it, or economic damages. They come back and they say, Judge, we think that was improper. We cite the RJR versus Townsend case, which says under these type of circumstances, you just can't do that. So the point being, and the court is all very well aware of the concept of specific contemporaneous objections. If you don't make contemporaneous objections, you can't let this go on. And then out of the jury's presence, just because you don't want to offend the jury, perhaps by objecting, and come to the trial court later and say, yeah, we heard all those comments. Yeah, we need a new trial on that basis, but we're just going to object now and let all those go. You just can't do that. And so our first position is that all of this was waived by the lack of a contemporaneous objection. If there is no contemporaneous objection, you get into the Murphy standards. Obviously, we argued those were not met. And even more importantly, they didn't argue in their motion for new trial, as they were required to, that Murphy would be met under these circumstances. So the first big hurdle is, and we cite a case law to that effect, you can't not object and say, I think a bad argument's coming. Let the bad argument that you think is improper happen, wait for a break, and then say, yeah, we were going to object to that entire argument.
For the sake of this argument this morning, let's assume it's preserved. And so we're not talking about Murphy and
yeah,
it's a preserved error here. And okay, there's maybe not an explicit, put yourself in your position. How much would you like to get if you were the plaintiff, Mr. or Ms. Juror? But it's an implicit golden rule argument. Where is, in your argument, I guess, is this isn't a golden rule violation for various reasons, but let's get to the merits of whether it's an implicit golden rule argument. At what point here, what other facts would make it in your mind something that is an improper implicit golden rule argument? I mean, because you're basically saying, even though he used you 55 times, whatever, he threw in Mr. Knapp 13 times. So therefore, we dodged the bullet here, for lack of a better term.
Well, starting with that, I mean, if you look at their initial brief on page 24, they all acknowledge, and there are cases, and we cited them to the trial court, that the use of the word you in and of itself obviously isn't per se improper. The court relied on the Bew versus Williams case, which we cited in our brief. And in that case, it's found that the plaintiff's counsel was simply dramatizing the devastating impact of the tragedy on the injured plaintiff by the use of rhetoric. That's exactly what happened here. He's saying, Mr. Knapp, you are going to experience this. Mr. Knapp, you're going to experience that. He was, and obviously it's proper and it's allowable to talk about the impact of what happened to the plaintiff and do that. We cited the Grushoff case, which the use of you clearly implied that it was dealing with what the plaintiff was experiencing.
Your two cases, the Grushoff and the Bew, but they don't really talk about how frequently the term you is used, do they? They basically says, if you put it in the context of, you, Mr. Plaintiff, or you, Miss Plaintiff, but yeah, I agree with you. At some point, the plaintiff's counsel has to be able to, give some kind of context. But
right,
it seems like your opposing counsel is, we start off saying Mr. Knapp, but then it's you are going to do this, you're going to do that, and it certainly is his argument, I guess, is implicitly he's asking you juries to understand, you're going to be part of this experiment. What's it worth to you? Which
he did. I mean, again, that is their argument. So the distinction, I mean, it's a fine line, I guess, or maybe not so fine. We cited, you, Grushoff, and Simmons, where they all found that it was not that jury was not being asked to determine what they felt, but being asked to talk about or experience or think about what the plaintiff experienced. Then you have the line of cases that talk about it being implied. The trial court in this case found that the Bew case and those lines of cases controlled, that the use of Mr. Knapp throughout, and there wasn't a specific ever request to the jury to say, put yourself in his shoes, how would this make you feel?
I agree.
And
Kind of a
after
clever
all
way
of
to do
that,
this. What if he hadn't even used the word you? You're saying it was a proper argument anyway. What does it matter what Mr. Knapp thought, what value he would put on his injuries? Why is that a proper argument anyway?
well, he's again it was taking the jury and saying, you have the right and your job is to understand what happened here. And I'm going to go through and talk about and summarize the testimony of what he
But this
experienced
whole
since the
experiment
accident.
thing, pretend that you're Mr. Knapp and put a value on what would it take for you to go through what he went through? Even if it's not putting the jury in those shoes, why is that a valid argument anyway? Of what Mr. Knapp would put on how he would value his experience?
Well, Your Honor, again, the valuation, there's no specific way to, that's required, or there are many ways the jury can be asked to value, what ultimate award they're going to present. There was no objection made when the experiment concept came, the experiment word was used. Yes, Your Honor.
I think Judge Harris is asking that, well, if Mr. Knapp's on the stand, you're not saying it's appropriate to in direct saying, okay, what do you think the value of your case is, Mr. Knapp? I mean,
Your Honor, no. And again, he wasn't asked that, but the point being,
well, my point being, that's not an appropriate question. You agree with that?
Yeah, again, this is argument during closing.
No, I know.
He's tying in what the plaintiff experienced, which is entirely appropriate to a monetary value, and it's a way of getting there, which is not. I agree with you on that. And there's no case law that specifically says you can't do that, and I get it. So again, the court has to wrestle with the question, which I think is clear, that all the context of this, including the specific findings of the trial court, were that the use of that argument was not a golden rule argument because it wasn't asked to put him in his shoes. I see I'm out of time. Is there any
other questions from the panel?
No.
All right. All right,
Thank
rebuttal. Thank you.
Thank you. I see I've got 3 3/4. I want to clarify my position on the golden rule issues a little bit. I do acknowledge with regard to the voir dire comments, I have an uphill battle if that was my only issue. I'm not abandoning it as an issue in and of itself, but I understand the realities of that point in and of itself. But that set the stage. And what is the golden rule argument? The word you, I think we all agree. The word you is sometimes used in a generic sense. That doesn't transform an argument into a golden rule argument. We also have cases saying that you don't even have to have the word you to make it a golden rule argument. That's clear from the SDG case. The issue is, is the jury being asked to put itself in the shoes of the plaintiff with regard to the determination of damages? That is what this was. This was an experiment to determine how much it would take you, nominally Mr. Knapp, to go through what he went through. If this was about Mr. Knapp, why are we framing it in terms of a hypothetical experiment? Mr. Knapp did.
Let me ask you this. I think it's about 11 paragraphs, trying to count real quick, of the argument here that you're challenging this golden rule. And if you took any of those, is there any sentence or paragraph in there that if you took on its own, you'd say there's a violation, or is your argument really based on a cumulative, looking at it in its entirety?
Well, that's a good question. I haven't dissected it. I read the argument as a whole. It was prefaced as an experiment to determine how much it would be worth for what Mr. Knapp went through, and then it goes through it. So I
guess the reason for my question is if I read the first paragraph and maybe that's not enough, and then I read the second and third and fourth paragraphs, and maybe that's not enough for golden rule. And then maybe I get to the fifth and it's getting close. Is there a time I should be making an objection?
Well, I thought Your Honor might be getting to that. And, as I've acknowledged, obviously, it was before the end of the argument that it was apparent that this was a golden rule argument. So how quick does counsel need to be? I think the context matters. When he raises the issue on the front end and he's assured it's not going to be golden rule, and it goes on At some point, yes. Ideally, he would have objected sooner than he did. But I think given where we were, it's not unreasonable to wait until the argument is where it is.
Well, the court had already indicated, the court right before when counsel came up and said, I worry he's getting, he's going to get near the golden rule. The court says, just be careful. I understand the concerns. It almost seems to me if there had been an objection somewhere along the line, the judge would likely have said, move on.
Well, I don't know. And we know that for certain because when the objection was made, the judge overruled it on the merits, saying he didn't ask the jury to stand in the shoes of the plaintiff. So we know that even at the end, when all of those sentences had been made, the judge didn't feel this was a violation. And I think that's what goes
I'm
back
trying to figure out the judge's comments, whereas I'll note your objection. I overruled it. I sustain your objection to some of what he said, but not all of what he said. Was that referencing the golden rule or was that referencing something else?
Well, I think the next part of what the judge says actually refers to the golden rule specifically.
Okay. All right. All right.
Yes, what it says is, I overruled your objection as to the golden rule because he didn't ask the jury to place themselves in the stead of the plaintiff. So the judge does specifically say that the objection as to golden rule is overruled. So would the judge have had sustained it or told him to move on? No, we know for certain. And I think that's part of the reason why I say this is preserved. The reason for preservation is to give the judge a chance to rule on the issue, on the merits. And that's exactly what happened. The judge took it as timely, overruled it, said the record is clear. I think every reason for the preservation rule is there. It was overruled on the merits, and I don't see any reason under these circumstances why the court would say it was not preserved for appeal. So I'm way out of time. I would ask the court to reverse and remand for a new trial on this, and on the other point, to at least remand for the limited discovery that we've requested.
All right. Well, thank you both. Of course, oral arguments a little different on Zoom than in person, but I think they work. And now modern technology will get around to deliberating by conference call. So anyway, y'all have a good day. And that concludes this oral argument.
Thank you, Your Honor.
Thank you. Nice seeing you all again.
Okay.